Hey guys, welcome back. And this is the last chapter, chapter 8, auditors' legal liabilities and defenses. So, in some of the objectives of this one, we want to describe common law rulings and auditors' legal liabilities to clients and third parties. We want to explain auditor defenses to negligence, negligent misrepresentation, and fraud. We want to explain the basis for auditors' statutory legal liability, the provisions of the PSLRA, the auditor's legal liabilities under SOX, and explain the provisions of the FCPA. So, is the auditor a watchdog or a bloodhound? That's really sort of the premise here. The question has been asked frequently to assess the legal liability of auditors, and for many years the answer has been that the auditor is a watchdog. So an auditor is not expected to be a detective, at least in the view of the audit profession. The public sometimes has a different view in that auditors are expected to disclose material misstatements in the financial statements, including fraud, and when they don't, legal liability may ensue. As discussed in Chapter 5, the environment of auditor liability has changed over the years and expanded to include a stronger obligation to approach the audit with professional skepticism. Auditors cannot simply accept the word of management, but must ask probing questions in order to satisfy themselves and the audit and to make sure that the audit conforms to generally accepted auditing standards. This is necessary for auditors to provide reasonable assurance that the financial statements are free of material misstatements, whether due to error or fraud. Auditors are expected to conduct an audit with due care in order to defend against claims of negligence and fraud. Simply stated, due care is based on a prudent person concept, which means to exercise the level of care that a reasonable person with knowledge of all the facts would do. Due care generally implies four things. First, the auditor must be competent as indicated by possessing the requisite skills to evaluate financial transactions. Two, the auditor has a duty to employ such skill with reasonable care and due diligence. Three, the auditor must undertake tasks with good faith and integrity. And four, the auditor may be liable for negligence, bad faith, or dishonesty, but not for mere errors in judgment, which is not the same as dishonesty as long as they acted in good faith. Auditors are liable to clients in which they have a contractual relationship called privity. Auditors also may be liable to third parties that rely on the financial statements for decision making, assuming there is an established relationship between the auditor and a third party. These standards are complex and will be discussed later in the chapter. The conditions necessary for a third party to prevail in a lawsuit against auditors for fraudulent misrepresentation include 1. A representation was made, 2. The representation was false, 3. The representation when made was either known to be false, a legal standard called scienter, or made recklessly without knowledge of its truth. Fourth, the third party did in fact rely on the representation. And 5, the third party suffered damages as a result of relying on that representation. According to the ethics standards of the accounting profession, auditors are expected to look for frauds, and the fraud triangle helps in that regard. There are times during traditional audits when the auditors have the opportunity to detect fraud, but there are two questions that they must be asked in order to establish legal liability. 1, could the auditors have detected the fraud? And then 2, should the auditors have detected the fraud? So think about the following questions as you read the chapter. What are the professional and ethical requirements for auditors to avoid legal liability to clients and third parties? 2, what legal actions can be taken against auditors? 3, what are the auditor defenses to fraud? And 4, what are the additional legal obligations, or what are the additional legal obligations under SOX, the Private Securities Litigation Reform Act, and the Foreign Corrupt Practices Act. So the accountants, according to the U.S. Supreme Court Justice Benjamin Cardozo, accountants must be prepared to compensate all foreseeable victims whose economic losses are proximately caused by the accountant's negligent statements. So the lawsuits could be hundreds of millions of dollars. They need to be aware of losses. And that's sort of the problem of getting involved in an audit. You're putting your name on the line. You need to do good work and make sure that you've audited those financial statements in a worthy manner, and in order to not be held liable for negligence. So, guys, hopefully you've enjoyed the class. Hopefully it's been a good time. And read through the questions this week, get ready for your final. And if you guys have any questions for me, just let me know. God bless you, and talk to you later.